I am now pleased to introduce our keynote speech. Judge Albert Hoffman, who is a judge on the International Tribunal for the Law of the Sea since 2005 and is currently president of UNCLOS. Judge Hoffman is unfortunately not here in person, but is here in video spirit. We will now display or show a video recording of his keynote speech.
Excellencies, distinguished colleagues and guests, it's my great pleasure to address you at this conference convened to mark the 40th anniversary of the adoption of the United Nations Convention on the Law of the Sea, also known by its acronym of UNCLOS, or I would prefer to refer to it as the Convention. At the International Tribunal for the Law of the Sea, the Convention forms the backbone of our work, and a well-thumbed copy of the basic text can be found on the desk of every judge and legal officer. I wish to thank the Center for International Law of the National University of Singapore, and in particular the chairman of the Center's governing board, Professor Tomiko, and the director of the Center, Dr. Nulifer Ural, for organizing this event and bringing together this distinguished group of experts. This conference allows us all the opportunity to pause and reflect on the achievements of the Convention to date and on future challenges facing the law of the sea. In my remarks this afternoon, I wish to look to the future and reflect first on the ability of the Convention to regulate new legal issues, and second, on the limits of the Convention in this regard. In this context, I note that the International Relations and Defense Committee of the United Kingdom Parliament recently published a report following its inquiry into whether the Convention remains fit for purpose. The report considers that, and I'd like to quote, the key achievements of UNCLOS were to standardize states' claims to maritime zones and their resources within them, and provide states with mechanisms for settling disputes when they arise." End of quote. Noting that the Convention has been considered a living treaty, which can change to reflect modern circumstances, the report concludes that if the Convention is not supplemented, nor its provisions further developed, it will no longer be fit for purpose in the 21st century. So much the report language. A large part of the success of the Convention to date lies in the fact that it provides a flexible framework for the international governance of maritime activities. Courts and tribunals established under the Convention have a key role to play in interpreting and applying the rules of the Convention to new legal questions. The approach of the Tribunal towards the interpretation of the Convention has been consistent, while at the same time innovative when called for. From its initial case law on the arrest and detention of vessels and crews, in which the Tribunal provided valuable clarification on the issue of the nationality of ships and developed the notion of ship as a unit, the Tribunal has gone on to deal with important aspects of resource exploitation, whether the fisheries or the non-living resources of the area, maritime delimitation, and the protection and preservation of the marine environment. For example, the Tribunal addressed some of the issues raised by illegal, unregulated, and unreported fishing in its advisory opinion of April 2015, delivered in response to a request submitted by the Sub-Regional Fisheries Commission. The Tribunal observed that the issue of flag state responsibility for IUU fishing activities is not directly addressed in the Convention. Therefore, this issue was examined by the Tribunal in light of general and specific obligations of flag states under the Convention for the conservation and management of marine living resources. The Tribunal clarified that a flag state is under a due diligence obligation to take all necessary measures to ensure compliance with relevant laws and regulations and prevent IUU fishing by vessels flying its flag and that the flag state can be held liable if it fails to comply with its due diligence obligations concerning IUU fishing activities. By clarifying the legal obligations of flag states, the Tribunal has facilitated the possibility of a future contentious case involving flag state liability for IUU fishing. I note that this advisory opinion was raised in evidence before the International Relations and Defence Committee of the UK Parliament as an example of how some of the challenges posed to the law of the sea can be addressed. The issuance of advisory opinions on the interpretation of the Convention is certainly one way in which the Tribunal can ensure that the legal framework of the law of the sea is adequate to meet the challenges that lie ahead. Thus, although certain legal issues were not contemplated at the time of the drafting of the Convention, this does not mean that the Convention has nothing to offer. Let us take, for example, the issue of legal questions arising in relation to climate change and sea level rise. At the time of the adoption of the Convention in 1982, scientific consensus on the effect of human activity on the global climate and the relationship between CO2 levels and temperature was only beginning to emerge. Issues such as sea level rise and ocean acidification as a result of global warming were not in the minds of delegates when the text of the Convention was negotiated. Nor were activities such as bioprospecting for marine genetic resources or ocean geoengineering. Fast forward 40 years, and last month, the Intergovernmental Panel on Climate Change released its 6th assessment report, in which it stated that, and I quote, "It is unequivocal that climate change has already disrupted human and natural systems, and that the rise in weather and climate extremes has led to some irreversible impacts as natural and human systems are pushed beyond their ability to adapt." End of the quote. The United Nations Secretary General described the report as, and I quote, "an atlas of human suffering and a damning indictment of failed climate leadership," end of quote. The next generation of legal scholars are examining how legal proceedings under the existing international law framework, such as advisory opinions from the Tribunal or the International Court of Justice, or petitions before international human rights bodies and regional human rights courts, can contribute to efforts to mitigate climate change. However, the focus on the Convention in the context of climate change mitigation has not been exclusively procedural. In terms of the substantive law of the sea, the question has been raised as to whether the obligations of states under the Convention are significant for climate change mitigation. Although the Convention does not contain any provisions specially addressing the issue of climate change, it may be noted that Article 192 of the Convention provides that states have the obligation to protect and preserve the marine environment. Moreover, under Article 194, paragraphs 1 and 2 of the Convention, states are required to take all measures necessary to prevent, reduce, and control pollution of the marine environment from any source, and to ensure that activities under the jurisdiction or control are so conducted as not to cause damage by pollution to other states and their environment. Some commentators have raised the question as to whether greenhouse gas emissions should fall within the remit of Article 194 when they cause or are likely to cause marine pollution. Several aspects of Article 192 of the Convention have already been addressed in the jurisprudence of the Tribunal. Thus, in the southern bluefin tuna cases, the Tribunal found that, and I quote, "the conservation of the living resources of the sea is an element in the protection and preservation of the marine environment, end of quote. In its advisory opinion of April 2015, the tribunal confirmed that living resources and marine life are part of the marine environment. In terms of the geographical scope of Article 192, the tribunal found that the obligation to protect and preserve the marine environment applies to all maritime areas. The Seabed Disputes Chamber has referred to the erga omnes character of the obligations relating to preservation of the environment, of the high seas, and in the area. Over the years, the scope and content of the obligations set out in Article 192 has been gradually developed through the jurisprudence of the tribunal. It is possible that the tribunal may be called upon to add to this jurisprudence in future if the states parties to the convention bring to the tribunal questions regarding the application and interpretation of the provisions of the convention dealing with the protection of the marine environment. Another example of an issue not specifically addressed by the convention is the use of maritime autonomous vehicles or autonomous vessels, or MAVs as they are referred to. Autonomous vessels are increasingly being used to conduct activities such as marine scientific research, mapping, and surveillance. Just a few weeks ago, the wreck of the Shackleton's Endurance, which ship sank in Antarctic waters in 1915 because of the flow of sea ice, was discovered at a depth of 3,008 meters beneath the Weddell Sea in Antarctica, using an autonomous underwater vehicle capable of working in deep water. The convention contains many references to ships and vessels, though it does not define these terms. However, several provisions of the convention refer to the manning of a ship or vessel, including Article 29 of the convention, which provides a definition of warships, including the requirement that they may be manned by a crew which is under regular and armed forces discipline. And Article 94, paragraph 3, which provides that every flag state must take measures necessary to ensure safety at sea, including in relation to the manning of ships and the training of crews. This raises the question as to whether provisions of the convention which refer to ships should be interpreted so as to apply to unmanned and autonomous ships, and how such vessels should be considered in the context of rules on navigational rights and jurisdiction. Although autonomous vessels of the type currently in use or development did not exist at the time the convention was adopted 40 years ago, it is conceivable that the legal framework of the convention can, nevertheless, be useful in addressing legal questions arising in relation to autonomous vessels. In this regard, it may be noted that in 2021, the International Maritime Organization's Maritime Safety analysis of existing ship safety treaties, assessing how they would apply to maritime autonomous surface ships with varying degrees of autonomy, and considered next steps for the regulation of such ships. The review highlighted several high-priority issues, including clarification of the meaning of the terms master and crew in relation to autonomous vessels, and the possible designation of a remote operator of an autonomous ship as a seafarer. The committee suggested that the development of a new instrument may be the best way forward to update the IMO regulatory framework. The example of autonomous vessels suggests that while some new legal issues can be brought within the framework of the Convention through interpretation of existing provisions, for example, where the intention of the parties was to give a term used a meaning which is capable of evolving over time. Not every new legal issue can be adequately addressed by the existing framework of the Convention. While the conclusion of the Convention undoubtedly constituted a remarkable achievement, the regime for the governance of oceans still has gaps which need to be addressed. This raises the question of how the framework of the Convention can be supplemented when necessary. It is a widely held view that the prospects for any renegotiation or amendment of the Convention by means of an intergovernmental conference are dim, and that the political conditions which allowed for the adoption of such an ambitious and comprehensive international agreement no longer exist. However, this does not mean that the law of the sea has remained static since the Convention entered into force 28 years ago. In fact, it has evolved in numerous ways, both as a result of the jurisprudence of courts and tribunals established under the Convention and through other more formal processes. First, the Convention also contains several references to generally agreed international rules and standards, in particular with respect to the protection and preservation of the marine environment. This allows standards which take account of new technology and new scientific knowledge adopted by international bodies such as the IMO to be incorporated into the Convention. Moreover, we have seen the adoption of two implementing agreements, the 1994 agreement relating to the implementation of Part 11 of the Convention, dealing with activities in the area, makes substantial changes to provisions of the Convention dealing inter alia with decision-making within the International Seabed Authority, technology transfer, limitations on production, and the enterprise. The 1995 implementing agreement on straddling fish stocks and highly migratory fish stocks adds substance to the obligations set out in the Convention to cooperate, to ensure conservation and promote the objective of the optimum utilization of fisheries resources by providing a framework for cooperation in the conservation and management of those resources. As you are well aware, efforts are currently underway to finalize the text of an international legally binding instrument under the Convention on the Conservation and Sustainable Use of Marine Biological Diversity of Areas Beyond National Jurisdiction, also known as BBNJ. The week before last saw the conclusion of the fourth session of the Intergovernmental Conference, convened by the General Assembly under the able leadership of Ambassador Rina Lee from Singapore, to elaborate the text of such an instrument. These negotiations represent an important opportunity to address some of the gaps in the Convention regarding the high seas and its resources. It is also possible that institutions established under the Convention, and in particular the Tribunal, may be called upon to settle disputes arising in the context of new legal frameworks. Among the many questions to be settled by the BBNJ Intergovernmental Conference is the question of a mechanism for the settlement of disputes arising in relation to the new instrument. It has been proposed that the provisions relating to the settlement of disputes set out in Part 15 of the Convention apply mutatis mutandis to any dispute between states parties to the new agreement. During the negotiations, a number of states raised the idea of modifying the dispute settlement mechanisms as provided for in under Part 15 of the Convention, including amendments to strengthen the role of the Tribunal. While this issue is still under negotiation, I believe it provides an interesting example of how the Convention might continue to evolve and how the past experience of the Tribunal in interpreting and applying the rules of the Convention may be of use in addressing new legal questions. This brings me to the end of my remarks, which I hope have offered some insight into the character of the legal framework established by the Convention and how it may evolve to address new legal questions. I wish you all the success and a very productive conference, and I look forward to the presentations to come, which I have no doubt will provide much food for thought on the achievements of the Convention to date and the challenges that lie ahead. Thank you for your kind attention.